Welcome to Salam Immigration. I'm Sheikh Asif Salam. I'm here to share with you some information about deportation. Deportation means someone is not only removed from the country but is also required not to come back to the country either forever or for 10 years. Deportation is for those who have committed any crimes here. We call them foreign national criminals. If someone is British, he would go to the prison if he has committed a crime, gets punished, and then he's back home. So he's not removed from the country. But if he's not British, if he's a foreigner and he commits a crime, then if the crime is serious, then he is removed from the UK. And when is it serious or when is it not serious has been categorically defined. If you have committed an offense which carries a sentence of 12 months or more, then you face deportation, which is called automatic deportation. That means you will definitely receive a deportation notice and then you fight it out if you can prove that you have enough human rights to overweigh the deportation, then the deportation can be cancelled. It's not just 12 months, but sometimes the courts they also hold that this offense has caused serious harm. So serious harm is a relatively subjective term. So if the convicting judge, sentencing judge, he says someone has committed an offense which has caused serious harm to someone, then again, without a 12 months or more sentence, you face deportation. Similarly, if someone is a persistent offender, like he has, say, convictions every now and then, or he offends every now and then, whether he has custodial sentences or not, but he is considered as a persistent offender, they may also face deportation. If someone has a sentence which is more than 4 years, then the deportation is forever. Forever means he can never come back. But if it is less than 4 years, then the deportation is for 10 years. You can come back within 10 years, but that doesn't mean you definitely come back. Or when you make an application, it will definitely get approved because 10 years have elapsed. No. Those who have not offended, who have never done anything wrong, even they get refused coming to the UK. So if someone has a bad past, he may get refused because of something else. They don't consider such applications very favorably, or if there is something wrong, they may not uh, allow a cushion or may not be a little liberal with you if you have had deportation due to your criminality. The deportation process and the basis has somewhat gone a radical change from the 28th of July 2014. New sections 117A to 117D were added to the 2002 Act to provide when the deportation will not take place and when the deportation should definitely take place. Deportation means that after evaluating a person, a deportation order is passed. So the deportation order has a life of 10 years normally, unless it is for all times to come for offenders of sentences of more than 10 years, more than 4 years. The deportation order can be revoked before 10 years or before its life. If the circumstances have changed, you can always make an application for revocation of a deportation order. Sometimes the application is done within the country, you make representations. Sometimes after you have been deported from outside of the UK, you make your representations for revocation of the deportation order. And such applications go to the Secretary of State, not the Home Office, but the actual Secretary of State. He personally would be approving cancellation or revocation of a deportation order before 10 years have passed. They expect such applications not before 5 years. So instead of 10 years, after 5 years, you may get away with deportation if the circumstances have materially changed, substantially changed. When a deportation order has been passed, then whatever leave you have, like if you have limited leave to remain or even if you have settlement or indefinite leave to remain, that gets cancelled. Even if you are not deported, but it still gets cancelled. There are circumstances when deportation order is not cancelled, but deportation doesn't take place. That means there are human rights, and regardless of what happens, your though your leave has been cancelled, the indefinite or limited leave, but you are still not removed because you get a fresh leave for the purposes of allowing you to have your human rights respected, and that will be a 10 years route. And in that route, you get 2.5 years, 2.5 years, and you keep on um, making applications for extensions. Now, when is it that we can get away with deportation? It's only when the human rights are very strong. When they are strong, this is also now uh, defined quite properly. Like they say, if someone has spent most of his life in this country, there are three legs to this thing. More than half of his life in this country, and he has integrated into the country socially, a good level of integration, and there would be significant, or rather very significant obstacles for him to re-establish, to get reintegrated into his country of origin if he is sent back. So if these three conditions, all of them are met, then he can get away with on that basis. However, if there, this is one exception. The other exception is that if the effect of such deportation would be unduly harsh on the partner, a British partner, or the qualifying child of the offender. Like if someone has a subsisting relationship with a British partner, and the deportation can bring devastation for that partner, whosoever is the partner, if this is unduly harsh in the circumstances, which is now a subjective thing, then the deportation will not take place. Similarly, if there are children involved, British children, then if it is unduly harsh for the children, then deportation should not proceed. And if someone has a sentence of more than 4 years, even then deportation can be cancelled or cannot uh, be proceeded with. If apart from any of the above two exceptions, I've given you two uh, situations where deportation will not proceed. So over and above that, if there are further very compelling circumstances in the case, then again the deportation should not proceed. If it proceeds, then the removal arrangements will be put in place. If someone who is a foreign national criminal has his dependents who are not British, then they can also be removed together with such deportee. Sometimes it happens that if a person is deported and he illegally sneaks back into the UK, then again it doesn't automatically mean that that person has to be thrown out immediately. But before throwing him out immediately, the Home Office will have to reassess his situation. If he still has very strong reasons because of human rights, he can still be allowed to stay here, although he's come back illegally. So deportation is a subject which is now becoming very common, and it has become a very hot topic because the Home Office is very strict. They are going after everyone who has 12 months or more of a conviction, and the Home Office is very tough in accepting human rights or itself giving away the deportation. So what they are doing is, in most of the cases, they would not budge an inch, even if there are strong human rights, even if there are British family members, they would find excuses to say no. Then the cases go into the appeals. The appeals are also difficult unless you have a very strong case and you fight it very well, very professionally. The chances of success would not be good otherwise. So this is something to be given very good attention. It's not something which you can just leave at the home office for them to decide. You have to do a lot. So if you have a deportation issue, do consult any good professional. We are also here to help, and we hope if you have a deportation, sadly, then you should hopefully get something good if you have enough human rights. Good luck and thank you very much.